Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today, the 3rd of February 2025, the sealed protective order in the Idaho 4 case was released to the public. This has to do with putting into place a protective order to protect health information related to Mr. Kohberger and his family members, which were disclosed in discovery to the state of Idaho. I would like to read this document to you, but I do recommend that you go to the public docket. It's stamped January 15th, 2025, although it was ordered by Judge Steven Hippler on the 14th. And it relates to a document that was submitted by stipulation by the defense on behalf of both sides. Stipulation, again, is an agreement between the parties. It begins by stating, pursuant to Idaho Rule of Criminal Procedure 17, that is the legal authority governing this request. It states, it is hereby ordered as follows, that this protective order shall govern the designation, disclosure, and use of medical and mental health records of the defendant and his family members disclosed to the state by the defense. Number 2, in this protective order, the term, quote, protected information shall mean the medical and mental health records of the defendant and his family members disclosed by the defense outlined in Exhibit A to their first supplemental response to discovery, filed with the court on January 9th, 2025. So what this means is that whenever you see the term protected information throughout the rest of this order, it is to mean, it shall mean, the medical and mental health records of the defendant, that's Mr. Kohberger, and his family members disclosed by the defense. It does not state specifically who his family members are, if it's his parents, if it's his siblings, or if it means something other than those family members. 3, access shall be limited to direct review by the prosecuting attorneys assigned to this case, and any further dissemination of the referenced protective information shall be prohibited other than the extent necessary for the prosecuting attorneys to prepare for court proceedings, including hearings, trial and sentencing, further stipulation, the parties, or order of the court. So this means basically, let's just say that the prosecuting attorney requires the assistance of someone else, perhaps a mental health professional that's an expert witness, or it might be even a paralegal that is assisting with the case, or any other direct review by any other person besides the prosecuting attorneys, then paragraph 3 directs what's supposed to happen. We go to the next page, page 2. The referenced protected information shall not be talked about or any specifics given during court proceedings, including hearings, trial, and sentencing, unless specifically agreed upon by the parties or permitted by the court. So in other words, if there is a hearing, such as the hearings that just happened on the 23rd and the 24th, in open court or during closed session, paragraph 4 says that this protected information shall not be talked about at all, or any specifics relative to the same given. Paragraph 5, the prosecuting attorney shall not produce any of the protected information to any unauthorized parties. So this means the prosecuting attorneys cannot copy these and send them out to someone without prior leave of court, permission of the court, stipulation by the parties, etc. 6, it shall be the duty and the responsibility of the assigned prosecuting attorneys to ensure that documents or things containing protected information subject to their control shall at all times be kept in a safe and secure fashion, to ensure that such information is not disclosed to or made accessible to persons other than those specifically authorized to review protected information under this protective order. The assigned prosecuting attorney shall be directly responsible to the court for fulfilling this responsibility. So what this basically means is now they have this protected information, the prosecuting attorneys. They are required to put in the appropriate protocols and procedures to make sure that this information does not go into unauthorized hands. And moreover, they shall be directly responsible to the court, that's Judge Steven J. Hippler, for fulfilling this responsibility and obligation. 7. The inadvertent or an unintended disclosure, including those persons authorized to view the information of protected information, shall not be deemed a waiver. Sometimes what happens is even the person who is the attorney for a client that has this information deemed protected, sometimes with internet things get inadvertently disseminated. And then after the fact, try to go back and fix it. Basically saying here that if it's inadvertently disseminated, that does not mean that there's a waiver, that the defense just basically, okay, well now everybody can see this information. No, that is inadvertent or unintended disclosure shall not be deemed a waiver in whole or in part of a subsequent claim of protection under this protective order, either as to the specific information disclosed or as to any such information, provided that the inadvertent or unintended disclosure is promptly identified by the assigned prosecuting attorneys and notice of the claim of protection is given to the defendant. So if this happens on the prosecuting attorney's side, they have to immediately do something to try to fix it and let the defense know what happened. This is what this appears to say. Upon final termination of this action, whether by settlement, that would mean to be a plea deal. You don't settle a criminal case with money or something like that you do with civil. Upon final termination of this action, whether by settlement, dismissal, or other disposition, the provisions of the protective order shall continue to be binding upon all persons or entities who are subject to the terms hereof. And then what Judge Hippler did is he crossed out, and the court shall retain jurisdiction for the enforcement of this order. Sometimes what courts do is they continue to retain jurisdiction to govern this specific issue. Judge Hippler said, nope, not going to do that, crossed it out. So they would have to then do another type of a proceeding if there was a disclosure in violation of this protective order. The defense, number 9, and the prosecuting attorneys may request modification of this protective order upon a showing of good cause. So at some time down the line, if the defense and the prosecuting attorney feel that there should be a change to this original protective order, they can go to the court and ask for a modification of the same. Upon a showing of good cause, they have to say why it is they would want this order to be added to, modified, language taken away, and the such. This protective order is sealed to protect the privacy of the information. The information subject to this protective order is confidential in nature and not appropriate for public disclosure at this time. So ordered January 14th, 2025. Judge Steven J. Hippler. So it appears that what the court did is basically entered in. It looked like this was a proposed document because the court was not having any of this retained jurisdiction. It appears that once this case is over, he's done. He doesn't want to be having parties come back later on and saying that there was a disclosure and they want something done about it. Nope. He decided that's it. That's why he crossed out, I believe, giving my opinion, pursuant to the First Amendment, why this happened. And you can see S.J.H. Steven J. Hippler, initials. If you would like to review this document, and I always recommend that you do, look at the documents, on the court docket and come to your own conclusions about what this case stands for. You're perfectly capable of reading the court documents. If you have any questions, any comments, please leave them. And if you haven't already subscribed to the channel, I would greatly appreciate it if you would do so. It really helps our channel grow. This is Kathy. As always, thank you for joining us here today.